Good morning, welcome. Thank you so much for joining us today for this Mock Employment Tribunal. My name is Katie Burley. I'm one of the employment partners in the team here at FSP. And you'll see on the screen that I'm joined by various people, both from our team here, and there are some other faces as well from Devereux Chambers. I'm going to do all of the introductions in a minute because I'm conscious that there's lots of people still joining in the background there. So I'll just run through a few opening points before we get started. So all attendees today are going to be on mute. Everybody listening from home will not be able to speak, but there is a question box we'll talk about in a minute. Obviously, this is an online event. Hopefully, we won't experience any technical difficulties, but if we do have any unfortunate incidences, we will obviously aim to resolve those as swiftly as possible, so please do bear with us. Now, the session today is being recorded. It's going to be sent out to all attendees over probably hopefully this afternoon, but if not over the next day or so. So look out for that in your inboxes. Now, the session today is scheduled to last for no longer than 2 hours. We'll do our absolute best to keep to that. There will be a short break towards the end as long as we're running on time. So that'll be just after the cross-examination and before our lovely judge gives her judgment. So that's an opportunity for you to have a think about what your outcome should be, go and get a new cup of tea, anything along those lines. So we'll let you know when that's going to come about. Right, if you do have any questions as we go through the session today, please do pop those into a question box. You should be able to see that on your screen somewhere. We'll endeavour to answer as many of those as we can at the end of the session. We've got quite a lot of people joining us today, so we may not get through them all, but we'll certainly do what we can. There's also going to be a few interactive polls that are going to pop up on your screen through the session. So for those of you who are watching live today, please do get involved with those. We always love to hear what your responses are to things as we go through and to get a bit of a take on how you're seeing the case going as we go. Now, I'm hoping that most of you will have received the bundle that's going to be referred to during the session today. That's all the documents, witness statements and those sorts of things. Now, those of you who signed up just very shortly before the session may not have received it, but good news is it should be in the handout section, which you should be able to see on your screen for the duration of while the session is live. So if you want to take a moment now to quickly pop onto that, download the bundle, and then you can hopefully refer to it as we go. Your feedback today would be absolutely massively appreciated. There will be a survey that should appear once the session closes. It's also going to be emailed out to all participants. So if you can just take a couple of moments, it's a very short survey, just to give us a few answers, a few pieces of feedback, that would be massively appreciated. Those of you who are able to complete it within the first 48 hours of the session being live will be entered into a draw to win a £50 John Lewis voucher with one individual chosen at random. So if you'd like to give us your feedback, we would be massively appreciative. Right, okay, just to then run a couple of introductions of the people that you can hopefully see on screen that we have today. Some of you may be familiar with the FSP employment team, or some of us that are here. We haven't got the full team today, but we have got Ian, who's one of the partners in the team, who's going to be co-hosting a session with me if I give him a moment to talk at some point. So morning, Ian. We've also got Emma on screen, who is playing the part of Pamela Wilson. We have got Victoria, who is playing the part of Evelyn Earthy. Hi, Victoria. We've got Callum, who is playing the part of our claimant, Francis Farmer. And last but not least, we have Annabelle, who's playing the part of Jasmine Good. Hi, Annabelle. You will see, obviously, there's a few faces I haven't mentioned. We are absolutely delighted to be joined today by three of the expert team from Devereux Chambers. We have Alice Mayhew KC, who is going to be playing the part of our judge for us. Morning, Alice. We've got Samuel Nicholls, who is playing the barrister for the claimant. And we've got Hitesh, Dhorajiwala, who is going to be playing the barrister for the respondent. We're absolutely delighted to have them all with us. And I'm just going to hand over to them very quickly so that they can introduce themselves and say a little bit about themselves, because you won't be as familiar with them. I don't know if Alice, you'd like to go first.
Yes, thank you. Good morning, everyone, and welcome. I'm going to be playing the role of the judge, and that means that I will be effectively conducting proceedings. I am a barrister of some 22 years cool now, and I took Silk a couple of years ago, and I do all sorts of tribunal and court work as well as investigations. So I'll hand you over now to Sam.
Good morning, everybody. I'm playing the part of the claimant's barrister, and I hope to inject a little bit of amusement into this at some point. I've been at Court of Bar 2006, and I only practice in employment law now. And over to Hitesh.
Morning, everyone. I'm also an employment specialist. I do a little bit of tax as well. I'm slightly concerned about Sam's suggestion he's going to inject some fun into today. I don't know what it's going to look like, but I feel like I might be the type of that. But I mainly do employment. I was called in 2019, and yeah, very excited to respond to council today.
Oh, well, thank you. Thanks, everyone. So just by way of just following on from that, really, is obviously the hope today is that you'll get an experience of what employment tribunal hearing might be like. You might see obviously cross-examination in action. And obviously, if anything does go wrong in terms of someone's on mute when they're not meant to be, someone's camera's off when it's meant to be, that is, of course, entirely deliberate, because that can also happen at mock tribunal hearings. And also, if my dog starts barking, that indeed is also deliberate as well. So yeah, hopefully give you a good insight. The other thing I should stress is obviously the views that are expressed today are those of the characters. It is entirely fictional. If your name is Francis Farmer or indeed anything else, that is a coincidence. It's not based on real life people. And indeed, I don't know Callum's views on climate change, but the views he'll be expressing today are those of his character and not himself. But to get you all started and get you engaged, let's get the first poll up. So we'll do the first poll now, which you'll get a chance to vote on, hopefully. So very simple one, just asking you, why did you sign up for this session? So you can select one of 4 options. It is entirely anonymous, but your options are: I am part of a claim currently in the Employment Tribunal. You might need to be a witness in future due to the role you have, just out of general interest, or the last option, which is the reason I'm here really, is you want to see FSP employees under cross-examination. So you can vote, click on one of those as and when you're ready, and yeah, we'll then shut that down and see why you're all here, and also just check that you are there. Never know on these sessions. So let's have a look. So here's the results. So 69%, most of you got sort of a general interest in the topic. Small percentage of you currently got a claim currently in the Employment Tribunal, so hopefully this will be useful for you. And also, obviously, those of you might have to do it in future, give you some insights as well. And yeah, D, seeing them under cross-examination, that was the one I clicked on as well. So, Katie, I'll hand this back to you for a brief summary.
Thank you. Yeah, so for those of you who haven't obviously had the opportunity to read the bundle yet, I'm just going to give you a very, very quick summary of the case. So, Mr. Francis Farmer, our claimant, was employed by a company called Ethical Earth Foods Limited. They are a retailer whose business involves the provision of ethical food and consumables. Mr. Farmer was employed for about 10 years until he was dismissed without notice. Obviously, wasn't terribly happy about that. So prior to his dismissal, Mr. Farmer suffered from a series of sort of short periods of absence. Now, he alleged that he was subjected to a number of discriminatory comments during this time by his female colleagues. Amongst those comments were suggestions that he was suffering from man flu. Now, Mr. Farmer also alleges that he was not only subjected to that, he was also told things like man up and to stop mansplaining during his dismissal meeting. Now, on the basis of that, he feels that his dismissal was due to his sex, and he is bringing claims for unfair dismissal, wrongful dismissal, discrimination and harassment. Now, Ethical Earth Foods say that's a load of old nonsense. They thoroughly deny their claims, and they are stating that he was actually dismissed due to some serious breaches of their social media policy, which amounted to gross misconduct. Right, so now you hopefully all know what it's about, and before we get started, I'm going to do one more very quick poll just to see how the floor is currently set. So the second poll should hopefully be appearing on your screens any moment. Here we go. So what do you all think at this stage, having known that you've seen the bundle or heard my wonderful summary there, what do you think the outcome of this case will be? So do you think the claimant, Francis Farmer, is going to win his case? Do you think the respondent, Ethical Earth Foods Limited, will be successful in their defence, or are you not really sure yet and think it's going to go way? Just give you a couple of moments for those results to come in before we take a look. Let's see. Oh, lots sitting on the fence. A lot of you sitting on the fence, and that's absolutely fine. And goodness, a very even split between the claimant and the respondent there. Well, I think it's certainly going to be an interesting day. We'll obviously do another one of these at the very end and see if anything changes. And once you've heard the evidence that's going to be before us. So, without further ado, I'm going to hand straight over to Alice to get proceedings commenced.
Good morning. I just want to give you a little bit of an introduction because we are in a situation which obviously is slightly unusual because you've only got a judge. This is a discrimination claim as well, so you would normally have a panel, and that would be a 3-member panel. One normally panel member would have an employee background and the other an employer background. In this instance, you can only have me as the judge. That has been agreed by the parties. Because we knew that there were not going to be any lay members, but that is quite unusual in this situation. You can only have employment judges in certain types of claims. Of course, this is not one of those. So that is the slight caveat to this situation, which makes it slightly unusual. And with that, I will now go straight into the hearing. So good morning, Mr. Nicholls. I understand that you are for the claimant in this matter.
I think he's on mute, Judge.
Mr.
Yes.
Nicholls, I can't quite hear you. Can you speak again, please?
I'm terribly sorry, I was on mute, yes.
Yes, I appreciate everyone being on mute. Thank you very much. But just make sure that when you are speaking, if you just remember to take yourself off mute, that'd be most helpful. Thank you for that. Mr. Dhorajiwala, I understand that you are for the respondents. Is that right?
Yes, Judge. Good morning.
Thank you. Now, I can see this is both a discrimination and an unfair dismissal case. Have you agreed who is going to be giving evidence first?
Yes, Judge. We understand Mr. Farmer will be giving his evidence first, so the claimant's evidence first.
Thank you very much. Obviously, because I don't have lay members, the advantage of that is that I'm pleased to say I've had the opportunity to read the papers ahead of time. So we do not need to adjourn to allow me to read into the papers. I'm happy to proceed straight into cross-examination of Mr. Farmer. Are you both happy with that?
Yes, Judge.
There's a couple of preliminary issues, Judge, perhaps before we get into major cross-examination. There's an error in the list of issues.
Yes, it's paragraph 12.
That's correct, Judge. And this list of issues was drafted by Respondents' Counsel. In their paragraph 12, he said there's a disability claim. There isn't. There isn't a disability claim at all. So I'm not sure where that's from.
Mr. Dhorajiwala, do you want to clarify, please?
Judge, that's of course right. You could say sex. I'm grateful to Mr. Nicholls pointing that out. I think he may have missed it when I sent him the draft as well. So I think that should be corrected to sex, yes.
So paragraph 12, the last word of paragraph 12, which page 35 of the bundle, should read sex as opposed to disability.
That's correct.
Can I clarify then that, save for that correction, you're both happy with the list of issues as it currently is drafted?
Absolutely, yes.
Yeah.
Thank you. And that's what I will need to decide today, is it?
Yes, those have got all the issues, yes.
Thank you. You said there were 2 preliminary points, Mr. Nicholls. Is there a second one?
Yes, there is. Judge, you've no doubt noticed that the paragraph numbering in my client's witness statement is correct. There's 2 1s and 2 2s. So I just thought I'd point that out just in case that causes any.
What page of the bundle that is, please?
That's 77 onwards. That's where you find Mr. Farmer's witness statement. And on page 77, there's the paragraph 1 and the paragraph 2, and then over the page on 78, there's paragraph 1 and the paragraph 2. Appreciate that may cause certain confusion when cross-examination.
How should we refer to the first 2 paragraphs if we run?
I'll just put them down as A and B.
So A, B, the first 2 paragraphs, and then we go to 1, 2, 3 and onwards.
Correct. Yes.
I'm grateful for that. Thank you. Is that all the case management?
One other thing, liability only.
Yes.
Mr. Dhorajiwala, are you happy with it being liability only at this point?
Judge, yes, I'm conscious of how much time we have. I don't think we can sensibly get through a remedy today.
I'm happy with that. We can deal with remedy if and when we get to it at the end of my liability decision. Are there any other case management issues from your perspective, Mr. Nicholls?
No, thank you. I'm very grateful, Judge. Thank you.
Ms. Dhorajiwala, anything from you?
No, Judge, nothing further from me.
In that case, shall we proceed to cross-examination of Mr. Farmer? Can I clarify how Mr. Farmer wishes to give his evidence? Does he want to affirm or give his evidence on a holy book?
I'll affirm, that's fine.
Thank you. Do you have the words in front of you, Mr. Farmer?
No, what words?
Well, in that case, I'm going to say a set of words. I'd like you to repeat after me, please. Okay?
Okay.
So I, Francis Farmer,
I, Francis Farmer,
do solemnly, sincerely and truly declare
do solemnly, sincerely and truly declare
and affirm that the evidence
and affirm that the evidence
I shall give
shall
be the truth, the whole truth and nothing but the truth.
shall be the truth, the whole truth and nothing but the truth.
Mr. Nicholls, would you like to introduce your witness, please?
Of course. Good morning, Mr. Farmer. Nice to see you again.
Morning.
Good morning. Your witness statement is in the bundle at page 77 onwards.
Yeah, it is. Can someone explain why we're changing my witness statement now? What was all that about with the A and the B?
Oh, Mr. Farmer, there's, as I explained to you, there's 2 paragraph 1 and 2 paragraph 2. So we've changed the first paragraph 1 to paragraph A, and the first paragraph 2 to paragraph B.
Right.
Just to help cross-examine.
Well, we're going to be fiddling with everyone else's witness statements as well.
No, we haven't fiddled with Farmer. It's fine. We haven't fiddled with it at all. It's the same evidence.
Perhaps I can assist. It's just a change to allow myself and others looking at your witness statement to understand numbering and to follow the numbering. It's not a substantive change to the content. So I'm happy to proceed as it is.
Yep, sure.
Wonderful. Thank you, Mr. Farmer. Can we just have a look at where it is in the bundle first, Mr. Farmer, before we go into any details? Can I just check, do you have a paper copy or are you using electronic copy?
Electronic.
Do you have 2 screens or are you just using 1 screen?
2 screens.
That's very helpful, thank you. If you could perhaps keep your witness statement up on 1 screen and the bundle and the hearing on the other, that would be very helpful. So your witness statement begins at page 77 in the bundle, Mr. Farmer. If you could just flick down to that or scroll down to that.
Yep.
You've got that, wonderful. And if you could go to page 87, which is the final page of your witness statement.
Yep.
And my version goes to 36 paragraphs, 38 with the A and the B.
Right.
Got that?
So sorry, 38 with the, well, I'm not sure what you mean.
Yes, because it's 1 to 36 and then A and B, so that's 38.
Sure, yeah.
Wonderful. And we see there's the statement of truth right at the bottom. My version is unsigned, Mr. Farmer. Is your version unsigned as well?
Yeah.
Yes, Judge, how would you like to deal with that?
I think as long as you have him declare that the statement of truth, I'm happy to proceed without having a signed copy.
Very well, thank you, Judge. Mr. Farmer, have you had the opportunity to read all of this?
What, my statement?
Yes, your statement prior to coming to court.
Yeah, I wrote it, yeah.
Yes, but read it recently.
Yeah.
I'm glad to hear you wrote it. Good. Could you confirm your full name and address for the tribunal then, please?
Yeah, Francis Farmer, 21 Standen Way, Bristol.
Excellent. Is there anything about the statement you need to change?
Don't think so, no, it shouldn't be.
Well, you see the word statement of truth in bold on page 87? See that?
Yeah.
Could you just read out the words that follow that, please, beginning I believe?
I believe that the facts stated in this witness statement are true. I understand that proceedings for contempt of court may be brought against anyone who makes or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth.
Thank you very much, Mr. Farmer. My learned friend, Dr. Dhorajiwala, will no doubt have some questions for you. So if you'd like to wait there, and I'll hand over to Dr. Dhorajiwala.
Thank you, Mr. Nicholls. Good morning, Mr. Farmer. Can you see and hear me?
Morning. Yep.
Thank you. Now, let's just crack on, shall we? I understand you began at Ethical Earth Foods as a store assistant in June 2010, is that right?
Yeah.
And eventually you were promoted to being a supervisor. I believe that was in 2016, is that right?
Yeah, September 2016, Colin promoted me.
Yes. And being a supervisor, that's a more responsible role, isn't it?
Well, yeah.
You'd presumably be held to a higher standard than you would as a store assistant.
Well, there's more responsibility. You've been promoted, right? So
More responsibility, higher expectations of conduct, that sort of thing, yes.
well, not necessarily, no.
Not necessarily. You don't think a supervisor is held to a higher standard than another employee?
No, I don't see any reason why.
Okay. And having worked at Ethical Earth Foods for, I think, around about 10 years at that point, you were aware of the kind of store it was, weren't you?
Sorry, I didn't catch that.
You were aware of the kind of store it was, weren't you?
Well, what do you mean by that?
Well, okay, so it's a store called Ethical Earth Foods. You must have understood, at least in broad terms, what the values of a store like Ethical Earth Foods were.
I suppose, yeah, I guess.
You suppose, and presumably by extension, you knew what its ethical commitments were as well.
Well, I don't really know what you mean by ethical commitments. I know that they've got that core values thing on the website, but I don't agree with any of that. So,
let's see if you agree with it or not. But I'm asking you must have been aware of that document. Well, you just told me you were aware of that document, so you understood the ethical commitments of a store called Ethical Earth Foods, weren't you?
if you want to call them ethical commitments, I think it's just a load of nonsense written on a website. But there we go.
Well, that what you call nonsense written on a website, that was how the company represented itself to the public, isn't that right?
Well, I suppose in some ways they did, but then in other ways, I mean, you know, Evelyn Earthy, she's jetting all over the place all the time. She's got all these cars that she drives around. So on the one hand, she says one thing, on the other hand, she's saying another thing.
Well, let's focus on my questions.
Just one moment. Apologies. Just two things. First of all, apologies, Dr. Dhorajiwala. I was actually told you were a Mr. by my clerk, so apologies for that misnaming. But more importantly, Mr. Nicholls, please could you try to keep your body and your face still, because it's very distracting seeing your responses to your witnesses' evidence.
I'm sorry, Judge. Yes, of course.
I'm grateful. Thank you. Carry on.
Thank you, Judge. I'm very grateful. I actually didn't see that, but I suspect it was very distracting. Right, well, Mr. Farmer, where we were talking about the commitments of the company. Can we have a look at page 38, please, in the bundle? Do you have the bundle in front of you?
Yep. Hang on.
Right.
Yeah.
So I think this is a document you just recently disparaged. Now, this is the first page of that document is at page 37. That's the core values and beliefs. But the part I want to look at is at page 38. Now, you'd agree that this is a statement of one of the core values of EEF, is that right?
Well, the document says core values and beliefs, and it's in that document. So, yeah, I guess so. I guess it's what's in the document.
Yes. And I suspect you've already read this, given you've referred to this document, but it's specifically this part. It's specifically a commitment to the seriousness of climate change, isn't it?
Well, yeah, that's what it says.
Yes. And nowhere in that document does it suggest that climate change is a hoax, does it?
Well, no, that's because it's wrong.
Right. And as you can see from the language here, it's something that the company's taking quite seriously, isn't it?
It's a bit overdramatic, so I guess if that's serious, then yeah.
Yes. And again, going back to this point that we've just discussed, having been at EEF for as long as you've been at EEF, you must have known how seriously it took a commitment like this.
No, I wouldn't necessarily say so.
Right. Well, you've been there for over 10 years at this point. Presumably, you've gotten to know some of the customers that worked there, not worked there, that came to shop there.
Well, yeah, I mean, I was a store assistant and then a supervisor, so yeah, I was dealing with customers all the time, and I was good at my job, by the way. That's the thing that none of them are mentioning. I was good at my job.
And being good at your job, you must have spoken to them.
Well, yeah.
You must have understood that one of the reasons they were shopping there was because of those ethical commitments.
Well, no, I think it was more because of the good service we provided, for a while anyway, and then things started going downhill.
Nothing to do with the fact it's a company called Ethical Earth Foods.
I don't think that's relevant.
I see. Now, I want to look at the relevant tweets in a moment, but first, can we just have a quick look at page 44 in the bundle, please? Are you there?
Yep, yeah.
Okay, so just recapping, you're a supervisor at the time this incident happened, yes?
Yep.
So presumably, as a supervisor, you must have known about the social media policy.
I don't know. I don't read all of the policies. It's not, it's not my job really.
Well, whether you've taken the time to read them or not, you must agree that it's a policy that does apply to you, particularly as a supervisor, yes?
I wouldn't say particularly as a supervisor. It's just a policy that the company has. I mean, they can write whatever they want.
Right. Well, let's have a look at what they've written. Can you have a look at subparagraph F, please? That identifies that it requires employees to apply the same standard of conduct online as they would offline. Would you agree?
Yeah, that's what it says.
Yep. Subparagraph K, page over, again, I'm summarizing, states that inappropriate content will be that which reasonably offends a third party.
Yeah.
And N, again, I'm summarizing here, states you must remain appropriate and polite when disagreeing with other people's opinions.
Yeah, that's what it says.
And just one page over, V, again, you can read it yourself, but I'm going to summarize. The essence of it is derogatory, offensive conduct or conduct that could bring the company into disrepute. That could be the disciplinary procedure. Do you see that?
Yep. Yeah,
Right,
again,
let's keep all. It is what it says. Now, let's keep all that in mind when we look at page 52, please. Can we go to page 52?
Well, hang on, because you've just skipped over something there, because paragraph L, right, and this is the key point, it says employees have the right to freedom of thought, opinion, and expression, and that we can use social media to communicate these. So you're just completely skipping over that. You're just cherry picking the bits that are important to you.
Well, Mr. Farmer, it's my opportunity to ask you questions. If you want to cover anything, that was the opportunity you had in your witness statement. So, as I said, can we go to page 52, please?
Right, but you can't just talk about the social media policy and skip the bit that defends my side.
Judge, I appreciate this is probably a point where it may be helpful to.
Yes, Mr. Farmer, your role here is to answer the questions that are put to you. If you can keep your answers to the questions that are asked, that would be most helpful. And as you've been told, obviously the witness statement is the point for you to be putting out your position, your evidence. Okay, and of course you've got learner counsel, I'm sure, who will pick up any points like that in summary at the end. Okay, so just answer the questions, please.
Yeah.
Thank you.
Thank you, Mr. Farmer. Thank you, Judge. So, Mr. Farmer, we're at page 52. Are you there?
Give me a second. Yep.
Right. Now, this is well, there are two pictures here. One is of a Twitter profile. Well, I should call it X profile now, but I'll keep saying Twitter, the legacy term. And on the right-hand side, a screenshot of a particular tweet. Now, on the left-hand side, we can identify quite clearly that's your profile with your name on it, isn't it?
Yeah.
It identifies you work at EEF in the bio.
Well, yeah, because the policy says that you've got to do that.
It identifies that you're based in Bristol.
Well, yeah, because I am.
Yeah. And we can see on the same page, on the same side of that page, a tweet that you wrote on the 8th of March 2020. Do you see that?
Yeah.
And this is a public tweet on a public profile, and you wrote that tweet. Is that right?
Yeah.
Now, just looking at the content of that tweet, I want to focus on the first half of it first. It's essentially just a denial of global warming, isn't it?
Well, yeah, because that's my opinion, and it's well researched. If you actually look into it, you'll see that I am right about this. So this is all a big stitch up, basically, just because Evelyn thinks that global warming is real, even though I mean, I don't know if any of you have been paying attention to the weather. We've had like the coldest April in years, but apparently it's warming. Doesn't make any sense.
Well, Mr. Farmer, I think maybe we don't need to get into the distinction between weather and climate, but I'm sure you're very familiar given all your research, but you're calling it a scam and crap.
Judge, I'm going to object to Dr. Dhorajiwala's commentary. We don't need the commentary. Cross-examination is for asking questions, not for snide comments about my witness's evidence.
I think the important thing is for Mr. Farmer to answer the questions and try to keep his answers relevant to the questions being asked. Mr. Farmer, if you can do that, that would get through your evidence quickly and efficiently. And of course, for both of you, if we could just try to keep this polite and courteous as we continue, that would be most helpful. Thank you.
Thank you, Judge, of course. Now, calling it a trap and scam is quite plainly in conflict, isn't it, with the climate change values the company has?
Oh yeah, because I disagree with those values, as you call them.
Yes, and so you must have known when you were sending this tweet out that it was in conflict with those values.
Well, yeah, it disagrees with the values, sure.
It disagrees with the values of the people who are likely shopping at EEF.
Well, some of them maybe, but not all of them.
Yes. And of those who do believe in it, if you look at your tweet again, you call them absolute morons. Is that right?
Well, yeah, but it's just, it's not. I'm not calling any particular person an absolute moron. It's just a general. People need to wake up. Basically, everyone's just sleepwalking into this, and if we don't use, language that's going to spark people and make them realise what's going on, then there's no point, basically. So yeah, I said absolute moron, but I wasn't talking about any particular person.
So but if you're someone who does believe in the seriousness of climate change, then that is directed at you, isn't it? You are called an absolute moron by someone called Francis Farmer who works at Ethical Earth Foods in Bristol. Is that right?
No, I didn't address it to anyone in particular.
Okay. Well, let's look at people who did respond to you. The first one we had from someone called Simon Green. Now, can you see that reply?
Yep.
And Simon Green says, totally unacceptable, especially from an employee who works at Ethical Earth Foods. Very disappointing tweet. Do you see that?
Yep.
And you can see he's actually, in fact, tagged Ethical Earth Foods in his response.
Yeah.
And how many times did he? Well, I'm not sure. I'm not sure if it's called retweeting anymore. But how many times was that retweeted?
It was retweeted 8 times, according to this.
How many times is it liked?
17.
Right. And then let's look at the next response from someone called Femi Stevens. This is so irresponsible. I thought climate change mattered to Ethical Earth Foods. Boycotting. Again, tagging Ethical Earth Foods in. So Mr. Stevens quite clearly thinks that climate change is a core value of EEF, doesn't he?
Well, yeah, that's his opinion. Just like my opinion is that climate change is a hoax. So
And
that's
in
the whole
fact,
point. That's the whole point of social media, is that you disagree with people.
Okay. And he's in fact suggested he's going to be boycotting EEF as a result of a tweet. Do you see that?
Yeah, but these people do this all the time, where they whinge about something online, and then it doesn't actually affect what they do in real life.
All right. Well, how many times was that tweet retweeted?
109.
How many times was it liked?
393.
It's pretty wide distribution there, isn't it?
Yeah, I suppose so. But listen, again, I don't think you understand how X works. Somebody reposting something doesn't mean that they agree with it, right? So just because it's being spread around, it might be people disagreeing with it.
Right. Okay. And putting all this together, would you agree that people who at least replied to your tweet expressed unhappiness with the sentiments that you tweeted?
Well, yeah, they did, but they're not. They're not the world.
But doing some quick maths on this, I'm just adding the likes together and the retweets together. I think it reached potentially about 410 people in terms of likes. Is that right?
Yeah.
117 people on retweets.
Yeah.
It's a lot more people that agreed with you by retweeting or liking your tweet, isn't that right?
Sorry, do you mean people? So you're saying more than the people who retweeted and liked my tweet?
The original, yeah.
Well, yeah, there's more, but that doesn't mean that there's more people who agree with them than agree with me.
Yes. Well,
Dr.
I'm conscious of my time.
So I was going to say, I think I've taken the point. I think you can move this on now.
Thank you. Well, I think it's my last point before I am conscious of my time, so this is my very last point. Just to put the point to you, Mr. Farmer, directly, a lot of people quite clearly disagreed with the sentiment you expressed, didn't they?
I don't think that's clear. I think you've got two people who disagreed. You can see that. I agree. I accept that. But you don't know anything about these people who have liked and retweeted. That doesn't mean that that you can't read into it like that.
Very well. Judge, again, I'm conscious of the time. I think I can deal with a range of points in submissions. Ms. Farmer, thank you. That's all the questions from me.
I'm grateful. Thank you for that. Mr. Nicholls, do you have any re-examination?
Yes, just one question, Judge. Mr. Farmer, Dr. Dhorajiwala took you to the social media policy and guidance at pages 44 through to 46. And you were explaining something when he interrupted you. I think it was about point L.
Yeah. Yeah.
What did you want to say about that?
So yeah, point L says employees have the right to freedom of thought, opinion, and expression, and can use social media as a means of communicating these. So, that defends my right to freedom of speech. So I feel Dr. whatever his name was just skipping over that point and covering the points that helps this side of the argument. You got to look at the whole policy is basically what I'm saying.
Thank you. Is that all you wanted to say on that point, Mr. Farmer?
Well, I just think, I've been dismissed here over expressing my opinions, exercising my free speech, when that's clearly what the policy says I'm allowed to do. So I think if anything, it's the company who have broken a rule, not me.
Thank you, Mr. Farmer. Judge, those are all the questions I have. I'm very grateful.
Thank you. I'm grateful for that. I don't have any questions. So, Mr. Farmer, that is your evidence. So you are free now to leave. Obviously, as your claimant, I suspect you'll want to stay. Is that your case, Mr. Nicholls, or do you have any other witnesses?
No, Judge, that's my case. I was going to suggest that Mr. Farmer may wish to turn his camera off, just in case.
Yes, and you can mute the sound too, Mr. Farmer, please. That would be helpful. Thank you.
All right, bye.
Thank you. Good. So that's the claimant's case. Then that moves us on to the respondent's case. Who is your first witness, please?
Judge, it's Pamela Wilson.
Pamela Wilson, thank you. Ms. Wilson, would you like to affirm or to give your evidence on the Holy Book?
Affirm, please.
Will you repeat after me then, please, these words? I, Pamela Wilson.
I, Pamela Wilson.
Do solemnly, sincerely and truly declare.
Do solemnly, sincerely and truly declare.
And affirm that the evidence I shall give.
And affirm that the evidence I shall give.
Shall be the truth, the whole truth and nothing but the truth.
Shall be the truth, the whole truth and nothing but the truth.
Good, thank you. Dr. Dhorajiwala, now for you, please, to introduce the witness.
Thank you, Judge. Ms. Wilson, can you see and hear me?
Yes, I can. Thank you.
Thank you. Just to check we've got the same document before us, I have a witness statement running to 10 pages and 41 paragraphs. Is that right?
Yes, it is.
Thank you. Now, just jumping to the start of that statement, which I think is page 88 in the bundle. Could you confirm your name and address, please?
Yes, my name is Pamela Wilson and my address is the care of Ethical Foods Limited, Unit 3, Commercial Yard, Bristol.
Thank you. Now, Ms. Wilson, have you recently read your statement?
Yes, I have.
Is it accurate?
Yes, yep. I helped prepare it.
Oh, sorry. And is there anything that you wish to add to it?
No, thank you.
Just at the end of your statement, I think yours is unsigned as well. So if I could just ask you to go
Yes.
to the final page, page 97.
Yes.
Just that final line above signed. Could you read that out, please?
I believe that the facts stated in the witness statement are true.
Thank you, Ms. Wilson. If you just stay there, I'm sure my learned friend, Mr. Nicholls, will have some questions for you.
Good morning,
Mr.
Ms. Thank
Yes,
you, Judge.
I was just going to hand over to you, so you go ahead. Thank you.
Thank you, Judge. Good morning, Ms. Wilson.
Good morning.
Just to drill down on something you've just said there, did I hear you correctly? You said you helped prepare your witness statement.
Well, no, I prepared the witness statement and sent it to my solicitor to finalise. I think they put the page references in, but I drafted it.
You drafted it all yourself from scratch, did you?
Yes.
Absolutely everything. They were your words completely.
Well, yes, I had a conversation with my solicitor on the phone. These are the words that I said, and this is the document that was produced, which I have read.
Very well. We might come back to that. We might come back to that. First of all, I want to take you to the disciplinary policy, please, which you'll find at pages 39 through to 43. Are you familiar with this policy?
Yes, yes, I've taken some other people through processes under this policy before. Yes.
You've taken others through this process. How many of those people lost their jobs?
I can't remember. I don't know.
All of them?
I don't think so. No, I've taken people through.
Well, how many people have you taken through a disciplinary? If you can't remember, I mean, it's something that would stand out in your mind, isn't it? Something quite so serious.
Well, no, I mean, as the manager of the store, it would fall on me to take people through this process. If I'd known in advance I was going to be asked this question, I would have checked, but I don't know. I haven't checked how many people exactly I took through the process. I was concentrating more on the situation with Mr. Farmer.
Is it 1? Is it 10? Is it 20?
As I've already said, I don't know. It was definitely more than 1. It's not as many as 20.
Can I suggest to you that the fact you don't know how many people you've submitted to a disciplinary process, which has got to be the most serious process in an employment context, suggests that you treat these things rather trivially?
Not at all. I just deal with what needs to be done through the process at the time. It reaches a conclusion and I move on to other matters at hand, which fall upon me as the manager of the store.
And can I ask you a question? How many men have you dismissed? Because Mr. Farmer's the only man left at the store. How many of the people you dismissed do you think were men?
I couldn't tell you.
You couldn't tell me.
No.
Very well. Let's have a look at the disciplinary policy then, please. Let's have a look at page 41 to start with, paragraph 1.1, right at the top of the page. Just
yes.
Have a read of that.
Yes.
So that sets out the purpose of the policy, doesn't it? And the key point there, or 2 key points, are that it is to ensure fairness and consistency. Yes?
Yes.
And fairness, I hope you will agree, is at the heart of any disciplinary policy, isn't it?
Yes.
Yeah, good.
I agree.
So anything set out in this policy, it's important to follow it to ensure fairness and consistency. Yes?
Well, yes, on the basis that, as best as we can in the situation, obviously each situation that arises is slightly different. Based on the scenario in front of me at the time, yes, we should. Yes,
and if you don't follow the policy, there's a danger that you will achieve unfairness rather than achieving fairness. Would you accept that?
Well, not necessarily, no. It will be based on this policy, but also the evidence before me at the time and what the allegations are, what the individual said in the meeting, all of those things.
Very well. Let's go down to paragraph 3.1 now, please. Just have a read of that.
Yes.
I'm going to break this down. It says that we will give you written notice of the hearing. You didn't give Mr. Farmer written notice of the hearing, did you?
I didn't. No, I didn't. I felt that after
I asked you about your feelings. I just asked you whether you gave him written notice.
No.
Moving on. That is to include sufficient information about the alleged misconduct or poor performance. You understand why an employee needs sufficient information about the misconduct or poor performance that they're alleged to have taken part in. Yes, you understand that?
Yes, and I made that clear to Mr. Farmer at the beginning of the meeting.
That's to achieve fairness, yes, and consistency.
Yes, and
Yes,
I
and
gave him a fair hearing.
The policy doesn't say you can do this at the start of a hearing instead of in writing prior to the start of the hearing, does it?
The policy doesn't, no, but if, as I was trying to explain a moment ago, I have my reasons for that.
Yes, I will come to those. And it also says, the policy also says that you have to tell the employee about the possible consequences of their alleged misconduct or poor performance, doesn't it?
Yes, and I did tell Mr. Farmer at the beginning that a possible outcome maybe of the meeting.
Again, not in writing and not prior to the meeting.
No, I do accept that point, but it was made clear to him at the beginning of the meeting. If he felt that then he needed time to go away and consider that, he could have asked for it.
So you think all the emphasis is on the employee to achieve what your policy says you need to achieve through the policy, fairness and consistency. That's up to Mr. Farmer to ensure fairness and consistency, is it?
No, it's not up to Mr. Farmer, but I can give him that information, and if he feels he needs time to go away to consider it or needs a short break, then he could have asked for that.
It's your duty as the employer to ensure that fairness and consistency is achieved through a disciplinary hearing, isn't it? Not Mr. Farmer.
Yes, and I gave him a fair hearing.
Thank you. And then it says, we see, and its possible consequences. After that, the reason why you must give the employee this information is to enable the employee to prepare for the meeting. Yes?
Yes, that's correct.
Yes, and the one thing Mr. Farmer couldn't do, because you didn't give him notice of the hearing in writing, sufficient information about the alleged misconduct and its possible consequence, the one thing Mr. Farmer couldn't do is prepare for the meeting, could he?
Well, he knew what he had done. I'm sure he knew when I said I needed to speak to him that he knew what it was about.
Did you give him the opportunity to prepare for the hearing?
He didn't have the full details in advance of the hearing, no.
So is the answer you didn't give him the opportunity to prepare for the hearing? Well, it's the third time I've asked you this question.
Yes, I accept. I didn't give him ample opportunity.
And
could I just ask? Sorry, one moment. I've just realised my laptop is not charging. Can I just very briefly plug it in? Is that okay? Because otherwise I might lose you.
Yes, I don't want to lose you. Yes, please. Please plug it in. Are you back with us, Miss Wilson?
Sorry, in a different room. Incredibly sorry.
Not at all. And because you didn't give him the information, notice of the hearing in writing, you didn't give him sufficient information about the alleged misconduct, its possible consequences, you didn't give him the opportunity to prepare, you completely failed to ensure fairness and consistency, didn't you?
Well, I accept he didn't have information in advance of the hearing to prepare, but I don't accept that he wasn't fair. It didn't have fairness or consistency, because I disclosed the information to him at the beginning of the meeting, and he could have asked for a short break at that time to consider it if he needed to.
Well, why does the policy have paragraph 3.1 in it at all then? If you can just give it to him at the start of the hearing rather than in advance and in writing, what's the point of paragraph 3.1?
Well, that is what we would intend would be the route that we would follow in most disciplinary processes, but in this instance, as I've tried to explain and you haven't allowed me to do so, I felt that it was particularly urgent for me to discuss the situation with Mr. Farmer because of the allegations having such a detrimental effect on our ethos as a business and our reputation as a business.
Yes, you did think.
Sorry, can I just interrupt one question? You mentioned that Mr. Farmer could have asked for and taken a break at the outset of the disciplinary hearing. Did you actually offer him a break at the start of the disciplinary hearing once he understood what the allegations were?
Not that I recall, no.
Was he aware of his ability to ask for a break in the way you suggest?
I don't know, you'll have to ask Mr. Farmer that.
And how would he be aware of that break if you hadn't offered it to him?
Well, he seems a pretty, well, he's certainly not a shy person in asking for what he wants and coming forward and stating his opinion. So I would have thought he wouldn't have been shy in asking for more time if he needed it.
Thank you, Mr. Wilson. Over to you, Mr. Nicholls. Thank you.
Thank you, Judge. You actually preempted the next topic I was going to move on to. If we actually look at the notes, Miss Wilson, you're absolutely right. You did consider that this was urgent. You don't accept that it actually was urgent. But instead of offering Mr. Farmer a route to ask for an adjournment, or instead of even being neutralised in saying nothing, what you've said is let's just get on with it. Page 53, then the notes of the disciplinary hearing. He says, I wasn't told I could bring anyone. I wasn't even given the courtesy of a written invitation. What's all this about? You say, let's get on with it.
Mm-hmm.
How's
Well,
that fair?
I do accept that I said that, but I think it's been quite clear to see from Mr. Farmer's evidence that if he believes in something, he wants something, he's not going to be shy in asking for it. So if when I said, let's just crack on with it, he didn't agree with that, he certainly would have spoken up. I think that's been quite clear from the way that he came across in his evidence.
Let me repeat the question. How is that fair?
Well, if that's my view that we should crack on because of the seriousness of the allegations that are put to him, then that's my view. He has the opportunity to say, no, I don't want to crack on. And then we could have had a discussion about how that could have looked. It wasn't as if he asked for us not to carry on and I denied that request.
Very well. And just one more topic before I wrap this up. Let's look at another thing you said to Mr. Farmer during the meeting, shall we? Page 55 of the notes.
Okay, just going. Thank you. Yes.
You told Mr. Farmer to stop mansplaining, didn't you?
I did.
Down from the top of page 55. Yes. Do you agree that term has sexist connotations to it?
I accept it to the extent that it says mansplaining. I was very offended by the way that he was talking to me, talking down to me, trying to explain a concept to me, which he obviously thought because I was a woman that I didn't understand.
We wouldn't say
it was all right for him to speak to me like that, but I wasn't allowed to say, don't mansplain something to me in return.
We wouldn't say it to a woman, would you? You wouldn't say a woman was mansplaining, would you?
No, but I believe he was talking down to me and explaining things to me in a very patronising manner because I was a woman.
Did you say no, you wouldn't?
Well, a woman wouldn't be talking to me in the same way that Mr. Farmer was because she wouldn't be a man. He was talking to me in that way because he was a man and I was a woman.
Very well. Well, you could have just said, Mr. Farmer, I feel you're patronising me, or you're being condescending, couldn't you? But you didn't choose those words, did you?
No, I didn't.
I would suggest that you deliberately didn't choose those words because you wanted to belittle Mr. Farmer because of his sex.
No, he was belittling me, and I wanted to defend myself and stand up for myself because I feel he was talking to me in a derogatory and patronising manner.
Very well. Thank you, Judge. I think that's my time. So.
Good, thank you very much. Is there any re-examination, please?
No, Judge, nothing from me.
I've asked my questions, so I have no further questions. So, Ms. Wilson, that is your evidence. You can now sign off if you don't want to attend or stay on, as the case may be. Who's the next witness, please, Dr. Dhorajiwala?
It's Ms. Earthy, the appeal manager.
Ms. Earthy, thank you. Ms. Earthy, are you going to affirm or give your evidence on a holy book?
Affirm, please.
Thank you. In that case, I'm going to say some words to you. If you can repeat them after me, I'd be most grateful. Please, can you say, I, Evelyn Earthy.
I, Evelyn Earthy.
Solemnly, sincerely, and truly declare.
Solemnly, sincerely, and truly declare.
And affirm that the evidence.
And affirm that the evidence.
I shall give shall be the truth, the whole truth, and nothing but the truth.
Confirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. Dr. Dhorajiwala, do you want to introduce your witness, please?
Thank you, Judge. Ms. Earthy, just check we've got this again. We've both got a witness statement in front of us. I have a witness statement from you that starts at page 98 and runs to 8 pages and 30 paragraphs. Is that the same statement you have?
Yes, it is.
Thank you. Just jumping to the start of that statement again. Could you confirm your name and address, please?
Yes, my name's Evelyn Earthy and my address is Ethical Earth Foods Limited, Unit 3, Commercial Yard, Bristol, Avon, BS3 1PQ.
Thank you. Thank you. Ms. Earthy, is this a statement that you've recently read?
Yes, it is.
Is accurate?
I believe so.
And is there anything you wish to add to it?
I don't think so.
In that case, could you look at the end of the statement on page 8, internal?
Yeah.
Would you mind reading the final sentence above signed?
I believe that the facts stated in the witness statement are true.
Thank you, Ms. Earthy. That's all from me for now. If you wait there, Mr. Nicholls may have some questions for you.
Good morning, Miss Earthy.
Morning.
There is no equality policy in the bundle, is there?
Not in the bundle, I don't believe so.
You don't have one, do you?
Not to my knowledge. I'm not really involved in day-to-day matters.
Okay, you're not involved in day-to-day matters, but the core values.
Yes.
You drafted those, didn't you?
Yes, I did.
So I'm going to suggest to you it's more important that you got those woke core values onto your intranet than having a quality policy. Yeah.
Judge, I'm sorry to interrupt, but I think if Mr. Nicholls was criticising me for commentary, I'm not sure on the woke core values is particularly the same. I'm not sure I should get away with it either.
Mr. Nicholls, can you just ask your questions in a way that doesn't comment on the documents in the bundle? Obviously, if you want to make a comment that something's missing, then you can do that in your closing submissions.
Very well. It's more important for you to get your core values out there, Ms. Earthy, than having a quality policy, isn't it?
I wouldn't say it's more important, but our core values are extremely important to our business, yes.
Well, how do you account for having one and not the other?
Can't answer that question, I'm afraid.
Very well. As well as being the founder of EEF, you're also the CEO and an employee of EEF as well. Yes?
Yes.
And in your witness statement at paragraph 2, we can see it at page 98, you say that the business is very much, you see the business is very much an extension of yourself. Yes?
Yes, very much so. Yeah.
And if we have a look at page, your witness statement at page 99, paragraph 4, you say that your commitment to reversing climate change is something that can't be underestimated.
Definitely not.
Very well. And if we have a look at the social media policy that we've been to already, we see it applies to employees. Yes.
Mm-hmm.
And in the core values, you go as far as to say, and that's page 38, that climate change is an existential threat to life. Yes?
Yes, it is.
Page 38, third line down, it's an existential threat to all life on Earth. Yes?
It is. Yeah.
And in your witness statement, sorry to get you moving about, paragraph 6, we find that you've delayed your holiday to the Bahamas. I'm sure we're all devastated by that. In order to conduct the appeal, is that right?
Yes, that's correct.
Thank you. Isn't it correct that you have several long-haul holidays a year all around the world?
I like to go on holiday, yes, long haul for the weather.
Yes, at least once a month. You spend a week at your villa in the Bahamas, right?
I try to go as often as I can to make use of it.
Yes. And isn't it correct that you also fly private jet? You never fly commercial like the rest of us.
I like to fly privately. It's more private for me and my family.
Yes, well, I'm sure I'd like to fly privately as well, but do you fly privately? Yes or no?
On occasion.
Yes. Every time you go down to your villa in the Bahamas, yes?
Every time? I'm not sure it's every time.
Okay. Isn't it also correct that you've got a fleet of what I'll describe as gas-guzzling motor cars, Rolls-Royces, Bentleys?
I do have some cars.
Yes. And if we looked at your Instagram account, and I looked at it this morning, we'd find hundreds of photographs of you enjoying this jet set lifestyle, the Bahamas, your Range Rover, your Bentley, your Rolls Royce. Isn't that right?
Not sure where my Instagram account comes into this.
But that's not.
I'm not sure I've had sight of this either. I'm not sure what documents in the bundle Mr. Nicholls is referring to.
Mr. Nicholls, is there a document in the bundle you're referring to?
No, it's not in the bundle, Judge. I would have asked for it to be put in the bundle, but up until about half an hour ago, it was a public Instagram account. It no longer is.
I don't understand why that means you couldn't have put it in the bundle before if you were going to be relying on it.
Well, Judge, it's only today that I've seen the relevance of it. I don't think this should cause Miss Earthy any degree of hardship in questioning her, because she must know the content of her own Instagram account.
Can you just tell me what the relevance of Miss Earthy's behaviour that you refer to in the Instagram account is, why that is relevant?
Yes, of course. Mr. Farmer's been dismissed for his views on climate change. They're so offensive to the respondent. He had to be dismissed. He had to be dismissed without basic fairness. And what the case we're going to discuss is that this isn't even a view properly held or actually held by Miss Earthy, the founder of Ethical Earth Foods, the respondent.
And so far, the evidence, as I understand it, is that Miss Earthy's agreed that she has a villa in the Bahamas, that she flies to it probably more often than not on private jet, and she has a fleet of what you describe as gas guzzling vehicles. What does the Instagram posts add to that I need to consider?
Well, Mr. Farmer was, of course, dismissed for tweeting or Xing or whatever it's called these days, his views on climate change. Miss Earthy seems to find it fit to post pictures of her jet set lifestyle all over the internet. That drives a coach of horses, we say, through the reason given by Ethical Earth Foods for Mr. Farmer's dismissal.
And how many pages are the Instagram posts that you wish to produce?
Well, I can't produce them anymore. It would be Miss Earthy that would have to produce them.
Oh, I see.
But
well, look, why don't you deal with it this way? Why don't you put to Miss Earthy what you say in an Instagram post that you've seen that are no longer public, see if she agrees, and then we'll have it in the record that way. I do think it's relevant, unless Dr. Dhorajiwala, you've got anything you wish to say in response to the suggestion that the Instagram comes in that way.
No, Judge, I don't think that's a sensible approach.
Do continue then, but please try and keep it short if you can.
I've got one eye on the time, Judge. Yes, thank you. And up until half an hour ago, isn't it right that anyone could have gone onto your Instagram account, which you proudly link to Ethical Earth Foods?
I believe so, yes.
And anyone could have seen these photographs of you climbing up the steps of your private jet, yes?
Well, unless I'd blocked them or removed them from my account, yes.
Yes, and anyone could have seen you in your chauffeur-driven Rolls-Royce, Bentley, Range Rover, other countless gas-guzzling cars, yes?
In my cars, yes.
Yes, and do you think that Ethical Earth Foods customers would have seen these photographs and found those photographs repugnant?
Well, it's never been brought to my attention, and certainly no one's ever made a complaint about my personal Instagram account, but they may have done, but I offset my carbon footprint in other ways.
I'm asking you what you think. Do you think customers
I don't believe so.
Your lifestyle, which you publicly put out there and link to Ethical Earth Foods, as repugnant to the core values of Ethical Earth Foods?
I think everyone is entitled to their opinion as to whether what they find my personal lifestyle like. They may find it repugnant, but no one's certainly ever said that to me.
Very well. And well, that's what you said Mr. Farmer's views were. Isn't that correct? Repugnant.
Yes.
To the ethical beliefs and values, and offensive to the customers. Yes. And that's why you declined his appeal. Yes.
Yes.
And what I'm going to suggest to you is there is a complete contradiction between, on the one hand, what you've dismissed Mr. Farmer for, and on the other hand, the lifestyle that you were proudly able to put out there on X. Yes?
Don't agree, no.
I'm going to suggest to you that Mr. Farmer's tweet, when my learned friend laboured the point about the limited distribution of his tweet, would have done far less damage to the core values of Ethical Earth Food than your own Instagram account.
Don't agree.
Thank you. Judge, I think those are the questions that I have for Miss Earthy. Judge, I think you're on mute.
Yes, sorry, that old chestnut. Is there any re-examination?
There's nothing from me.
Good, thank you, Miss Earthy. Then I have no questions, so that is your evidence. You don't need to stay on, but it's up to you if you do stay on. I think you have one more witness, Dr. Dhorajiwala. Is that correct?
That's right, Judge. It's Jasmine Good.
Miss Good.
Yes. Hello.
Good morning.
Morning.
Do you wish to affirm, or do you wish to give your evidence by way of a holy book?
I'll affirm, please.
Good, thank you. All right, so I'm going to read some words out to you. If you can please repeat them back to me. Yeah. I, Jasmine Good.
I, Jasmine Good.
Solemnly, sincerely, and truly declare.
Solemnly, sincerely, and truly declare.
And affirm that the evidence.
And affirm that the evidence.
I shall give.
I shall give.
Shall be the truth, the whole truth, and nothing but the truth.
Shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Thank you. If you can introduce your witness, please.
Sorry, am I allowed to just say something quickly?
Insofar as it might be relevant, does your counsel know what you want to say?
Yes, I just wanted to apologise in advance if there's any issues with my connection, but I'm actually joining the hearing from Thailand today.
From Thailand?
Yes.
Right. I don't think I've received, or the tribunal's received, an application for evidence to be given remotely. I certainly haven't seen anything in the case management files. Now, I know sometimes not everything's put on it. So is there an application, Dr. Dhorajiwala?
Judge, not that I've seen either, actually. I think this might be the first time I'm hearing about this as well. Appreciate this puts us in some difficulty with Ms. Good's evidence.
Mr. Nicholls, were you aware that this witness will be giving their evidence remotely?
No, Judge, I've had no notice of this. What I can help the tribunal with as well, because I've had a witness from Thailand who have wanted to give evidence from Thailand. They're not on the Foreign and Commonwealth Office list of countries where permission has been given in advance for a witness to give evidence from.
So they're not on the list, and no application has been made for permission from this state. Is that right? In that case, I can't see how this witness can give evidence.
You're absolutely right, Judge.
I think that would be right, Judge, yes.
Ms. Good, I'm afraid that because you're in Thailand, there are rules now about witnesses giving the evidence from other jurisdictions. And in order for that to happen, permission needs to be sought from that jurisdiction. Now, there is an agreed list, which means that certain jurisdictions have accepted witnesses giving evidence remotely without each individual case having to go to that jurisdiction for individual permission. But Thailand is not one of those. So unless permission's been obtained from Thailand, from that jurisdiction, it means that you can't give evidence. And unfortunately, I think your counsel wasn't aware that you were overseas in Thailand today for the purposes of giving evidence. So that permission hasn't been sought. So I'm afraid that means that you can't give evidence today.
Oh, I'm sorry, I didn't realise. My solicitor didn't mention that to me at all. I don't think he thought it was an issue. I'm on a family holiday. I did let him know.
Yes, it's a relatively new thing, and I'm afraid it means that sometimes it can be missed, unfortunately. I'm sure your counsel will explain to the solicitor the difficulties that have arisen as a consequence of that permission not being sought. But unfortunately, for the purposes of your evidence, that is the end of the matter. I can't hear your evidence, but without permission from Thailand. Okay, so is there anything further, Dr. Dhorajiwala, in terms of your case?
That's the respondent's evidence.
All right, so that then moves us on to closing submissions. Ms. Good, you don't need to stay on. If you want to drop off, then you're more than welcome to.
Okay,
we're going to move on
you.
to, thank you very much, closing submissions. I don't have anything, I don't think I've received any skeleton arguments or written documents. Is that right?
That's right, Judge, yes.
All right then. In that case, let's move on to closing submissions. Do you have agreement as to who's going to go first?
Yes, Judge. I'll be making my submissions first. I think Mr. Nicholls will be in reply.
Good. Then, just looking at the timetable, then I think if you can keep it to below 10 minutes, preferably close to 5, that would be helpful. Thank you.
I'll try my best, Judge. I'm hoping it will be. Judge, thank you. If I may then start. Of course, this claim concerns three matters: the unfair dismissal claim, the direct discrimination claim, the harassment claim, and of course there's the this jurisdiction question alongside all of that as well. I'll keep my submissions brief. On the unfair dismissal, Judge, it's the respondent's position, as it consistently has been since the claimant's dismissal on the 15th of March in 2020. The reason for the dismissal was his conduct, and that was namely posting an offensive tweet that denied the effects of climate change. It was in material terms accepted by the claimant today in cross-examination that this tweet was contrary to the core principles of the respondent. And in addition, the tweet was phrased in an offensive manner, which was contrary to the respondent's social media policy. Now, that tweet was seen by a number of people, retweeted by responses rather critical of his tweet were retweeted by a wide number of people as well. The claimant was given the opportunity to delete this tweet in his disciplinary meeting, but refused to do so. And the crucial point is that this tweet did significant damage to the respondent's reputation, a company called Ethical Foods, and in some was an act of gross misconduct on the part of the claimant. This is the sole reason for the claimant's dismissal. the avoidance of any doubt, it's denied that any other factor beyond this tweet was a reason for the dismissal. For this reason, judges submitted that it was wholly within the band of reasonable responses for the respondent to dismiss the claimant for this reason. Just turning to procedural fairness very briefly, I suspect this will be a point Mr. Nicholls will be addressing you on as well. Submitted in the circumstances, a fair procedure was followed. The respondent carried out as much investigation as it sufficiently needed to into this tweet. The source, the content, the reach of that tweet are patent on its face, such that there's no need for a protracted investigation. And although it's admitted, it's not admitted that there are any procedural failings. Any such failings had been remedied by appeal hearing, and it's notable that the claimant failed to mention any allegations of procedural unfairness as part of his appeal. And it's submitted that the reason the claimant didn't do so was because he didn't consider there to be any procedural failings at the disciplinary stage. For that reason, Judge, it's submitted that in all the circumstances, the dismissal was procedurally fair. And if the tribunal is not with me on that point, then without prejudice to those submissions, it's submitted that for the reasons I've already outlined to this tribunal, the claimant would have been dismissed in any event if a fair procedure had been followed, and for that reason, additionally, his conduct quite plainly contributed to the entirety of his dismissal. Moving on, Judge, to the direct discrimination claims. Now, it's submitted that the claimant was not directly discriminated against. Now, I've made my submissions in relation to the reason for dismissal. I'm not going to repeat those, in order to emphasise that there was no discriminatory motive or reason behind that dismissal. In summary, it was not a factor. Insofar as the remaining elements of that claim, the man fluke comments are not properly classified as less favourable treatment. Now, Judge, I appreciate Ms. Good did not give evidence. I submit that the tribunal can at least take account of that statement and place what weight it deems appropriate on it. But as we'll see in her statement, as is seen in her statement, and is accepted by the claimant, these comments were made in good faith and in the context of a light-hearted work environment in which the claimant would also actively participate and would never object to. It was therefore not properly characterised as less favourable treatment, and the claimant must necessarily fail on that limb. And even if it doesn't, Judge, the treatment was no less favourable than the treatment a hypothetical comparator would have experienced, as those kinds of jokes were commonplace in the respondent's workplace. Moreover, as for the mansplaining point, again, this is not less favourable treatment. As Ms. Wilson explained very clearly in her evidence today, it's a term that adequately and appropriately describes the claimant's behaviour. It's when he became patronising and condescending to Ms. Wilson in the disciplinary hearing is when she used it. And as the claimant's witness statement accepts, he seems to understand that that's how the term mansplaining is understood and used. And for that reason, Judge, it is an accurate label for what the claimant was doing. It shouldn't be perceived, or the tribunal should make any finding as to it being less favourable treatment. And finally, Judge, there's obviously dispute as to the man up comment in the disciplinary hearing. It simply denied that Ms. Wilson never used that phrase, and this was put to the claimant in due course. Moving on, Judge, to harassment. Again, they're largely brief submissions because I've already covered all these points. On the dismissal, Judge, you've already heard my submissions. I'm not going to labour the point. On man flu, again, in the circumstances, it's a situation where the claimant was voluntarily engaging in a sort of, and I use the phrase obviously with care, but banter in the workplace that gave rise to those man flu comments. And again, I refer the tribunal to Ms. Good's witness statement at some point. And again, mansplaining, Judge, I've already made my submissions. In summary, that concludes my submissions on the substantive points. As for the jurisdiction question, we're principally concerned with the man flu comments as part of the jurisdiction issue. In my submission, they are substantially out of time, and Judge, it would not be just inequitable for the tribunal to extend time for the claimant to bring claims in relation to those matters. Judge, those are my submissions, unless it can be of any further assistance to the tribunal.
Thank you very much. Mr. Nicholls.
Thank you, Judge. I'll deal with unfair dismissal first. The dismissal was obviously procedurally unfair, desperately unfair, in fact. There was no proper investigation. There was no notice of the disciplinary hearing, contrary to the clear requirements of the disciplinary policy. There was no communication of the allegations prior to the hearing. There was no communication of the possible consequences at all. And it's particularly important when one considers the weight placed by the respondent on the claimant's refusal to take down the tweet in its rationale for dismissing the claimant. We also say that it's obvious, given the hostile animus that Miss Urphy had towards the claimant, that she should not have been the appeal manager. We also say that the dismissal was substantively unfair, and moreover, that the dismissal was because of the claimant's sex, the fact he was a man, and had nothing to do with the tweet. And I'll come back to this. Miss Urphy's own lifestyle, that my learned friend did his best to cover up, was publicly evident in her Instagram account, and it shows that neither she nor EEF, we say, has the commitment to ethical practices that they would otherwise like the tribunal to believe they had. And that is important because that is the rationale that they used to dismiss Mr. Farmer, my client. Importantly, Miss Urphy had no issues with members of the public knowing about her lifestyle, which is in clear contradiction.
Mr. Nicholls, can I just ask you one question? Does that issue of Miss Urphy's behaviour go to consistency, or is it more than that?
It's more than that. The rationale that the respondent used to dismiss my client was that his views were repugnant. That is a word that's in the appeal outcome letter. His views were repugnant to the core values of ethical earth food. So one of your functions judges to look at those core values and say, well, is this the reason for dismissal? Is the core values, the alleged breach of the core values, the real reason, or is there something else going on here? And we say there's something else going on here, and the something else was the sex. We've essentially placed the burden on to the respondent to prove a non-discriminatory reason for the dismissal, and they failed to do so. That's essentially where we are. So we invite the tribunal to find that the reason for dismissal was the claimant's sex, rather than the fabrication that the respondent has come up with. Also, given the claimant wasn't given the opportunity to consider removing his tweet, he was just asked whether he would be willing to take it down rather than take him to the part of the policy that says he can be made to take it down. That also renders the dismissal substantively unfair. I've touched on the fact that we said the dismissal itself was an act of discrimination, but there are also three discrete acts. Jasmine Good using the term man flu. We say that clearly happened, clearly related to the claimant's sex. Clearly, it wouldn't have been said to a woman. The comment was clearly capable of violating the claimant's dignity. We say that's either discrimination or harassment. Can't be both, one or the other. It doesn't really matter which one's which. Mansplaining, again, this clearly a discriminatory comment, documented in the notes this time, wouldn't have been said to a woman, clearly, obviously related to the claimant's sex. And it is particularly egregious in the context of a disciplinary hearing, which was sprung upon the claimant in the circumstances I've already taken you to, in circumstances of gross unfairness. Finally, the man up comment. I invite the tribunal to find on the balance of probability that this was said. It is in line with what we say is the culture that's prevalent at the respondent, the man flu and the mansplaining. Being comments that were made, that we know were made. It is not a stretch for the tribunal, if it were to find that the man up comment was said as well. Clearly, it wouldn't have been said to a woman. Clearly, it's related to my client's sex. So when said individually, these comments amount to discrete acts of probably harassment as opposed to discrimination, but I'm not sure it matters which. And when collectively, what they amount to is evidence of a culture of discriminatory practices against men at the respondent's business. Judge, those are one final submission on time. Those were my submissions on the substantive issues. Even if, Judge, you find these matters are out of time, we say it's a continuing act, obviously, and we say that it would be just and equitable to extend time. The respondent has not identified any degree of prejudice that it would suffer from by you extending time. The only prejudice caused to the respondent was by its own incompetence in not getting the necessary permissions for the witness to give evidence from Thailand. Those are my submissions, Judge. I believe you're on mute, Judge.
Apologies, trying to reduce the echoes. We will now, this is for everyone, slightly taking a step back from being judged, we're going to take a break, and after the break I will give my judgment. It's now, Ian, I can see you're popping back. Do you want to take control of the break then?
No, that's fine. I was going to suggest maybe we'll have a comfort break, come back, let's say 5 minutes, 10:30 or so. And if anyone's got any questions in the interim, type them into the question box, because hopefully if we're back by that sort of time, we can you can put your questions to the panel, either on the process or the legal points, and yeah, we can have the judgment when we come back. So see everyone in 5.
Wonderful. Okay, thank you ever so much for joining. I hope you had a good couple of minutes break there. Before we get into the judgment, we're just going to have another very quick poll just to see whether those opinions have changed from where they stood earlier in the session. So the next poll should hopefully be popping up on your screen very shortly. And that is going to cover the question of what you think the outcome will be now. Right, there it is. So be interesting to see if those opinions have changed. So do you think, on the basis of obviously everything that you've heard today, that Francis Farmer, the claimant, is going to win his case? Do you think it's going to be the case that Ethical Earth Foods Limited, the respondent, will be successful in their defence? Or are you still not sure and still sitting slightly on the fence and not sure which way it could go? And give everyone just a couple of moments to have another look and select which way they want to go. Let's see if those results are going to pop up. Here we go. So what have we got this time? Wow, gosh, a real shift there. Clearly, people have now made a quite large slide down towards the claimant, thinking that he's going to win. Obviously, very convincing witness evidence and obviously an exceptional fierce cross-examination there by our barristers. So, well, it's wonderful to know what you all think. Thank you ever so much for answering that poll. Obviously, we know what you think. I'm now going to pass you back over to Alice to deliver her judgment. Alice, over to you.
Thank you very much. I've deliberated over the break and have now arrived at my decision, and I propose to deliver it shortly. The parties may request full written reasons if they wish in due course. I have considered submissions to the parties, the evidence contained in the hearing bundle that I've been taken to, and the evidence of all the witnesses in the case and documents referred to in those witness statements. Before I deliver my substantive decision, I have concluded that it would be just and equitable to extend the time limit in order for the tribunal to consider those complaints of sex harassment or discrimination, which is specifically the allegation relating to man flu that occurred outside the time limit for bringing a claim. In reaching this conclusion, I attach particular weight to the fact that the first respondent has not identified any prejudice to its position. In fact, it admits the factual basis for the claim. In summary, I've concluded the following in relation to Mr. Farmer's claim. Unfair dismissal. I conclude that the dismissal was unfair. Direct discrimination. I conclude that the respondent was subjected to direct discrimination with respect to the Complaint Act of dismissal, but not by reference to man flu during his employment, as well as being told in the course of his disciplinary to stop mansplaining to Ms. Wilson. Harassment. The references to man flu during the employment, as well as the suggestion that he was mansplaining and the comment about manning up, all constitute acts of harassment. I will now give a little bit more detail in relation to those separate findings. First of all, unfair dismissal. Having considered the witness evidence in particular, I conclude that the reason for the claimant's dismissal was his sex and not his alleged conduct by way of the tweet that he sent. It was therefore unfair. I was not persuaded, particularly having heard the evidence of Evelyn Earthy in cross-examination as to her own social media presence, which was clearly associated with EEF, that EEF placed as much emphasis on their core values as they would have the tribunal believe. Ms. Earthy's own very public social media activity contradicts EEF's alleged stance on environmental issues. When this is combined with the acts of harassment that I have found proven, and the fact that Mr. Farmer was the only man employed by the first respondent at the Bristol store, and the speed with which they dismissed him and the procedural failures, I draw an inference of sex discrimination, which the first respondent has failed to discharge. Furthermore, there were also substantial procedural failings in the procedure for the claimant's dismissal. At the disciplinary stage, the allegations against the claimant were not communicated until the disciplinary meeting itself. The claimant was not provided with any written notice of the hearing, informed of any right to be accompanied to the hearing itself, or provided any material to enable him to prepare for the hearing. All of that was in breach of EEF's own disciplinary policy. No witness evidence was provided to the claimant. These procedural failings also render the dismissal unfair. I do not accept that the appeal process was sufficient to adequately address or remedy the substantial procedural failings seen at the disciplinary stage, particularly in light of the prejudgment of the issues by Ms. Earthy. Direct discrimination. I have concluded that Mr. Farmer was not directly discriminated in relation to the comments about him suffering from man flu, as well as being told to stop mansplaining in the process of his disciplinary hearing. For the reasons below, I conclude that these acts are well-founded claims of harassment. Harassment. I've concluded that the claimant was harassed in relation to the man flu, man up and mansplaining comments for the following reasons. I do not accept Ms. Wilson's evidence that she did not tell the claimant to man up in his disciplinary hearing and make a finding of fact to the effect that she did make such comment, which is the same character as the other comments made. With respect to man flu, it was accepted by the respondent that their employee did make these comments. I do not accept that this was merely good-natured banter. In so doing, in relation to mansplaining, I accept the respondent's evidence that there is a degree of nuance that must be applied when considering terms such as this, not least due to historical or institutional dynamics that exist between men and women. However, I conclude that the use of all these three terms constituted unwanted conduct. I find that it's patent that these terms related to the claimant's sex and had the effect of creating an offensive and humiliating environment for the claimant. This concludes my decision. We will now need to set dates for a remedies hearing to decide the issue of quantum. Thank you. That's the decision.
That is brilliant. Thank you very much, Alice. So happy days for Francis Farmer, winning their case on a number of different levels, including the harassment elements as well. So I guess I firstly should just say thank you for everyone for taking part. Some very good acting in there as well, like giving up jobs as employment lawyers to star in EastEnders, no doubt, future careers. So yeah, please do type your questions into the question box. We've had a number come through already, so I suggest that we just sort of plow on with them and see how many we can sort of get through in the time, really. And there's a good one here, I think, for Alice, which is a question: is it normal for judges to ask questions when witnesses are being cross-examined? Alice.
Yes. So some judges will, some judges won't. It really is a matter of the judge's discretion. And I think when they do ask questions, either during or at the end of the cross-examination, it's really important to listen to those questions because they can give you quite a good indication of what the judge's concerns are about a particular issue. So the answer is you should prepare for questions to be asked during cross-examination, but the judge may not. It's a matter of that judge's choice.
Thanks, Alice. So I'm wading through them alongside Ian, so we'll tag team them and see as they come in. I think actually, Ian, if it's okay, I might just send one in your direction. There's been one that was asking how you decide which witnesses to call, especially if you've got a lot, is the way it's been worded. So if there's multiple witnesses, how do you pick?
Oh, it's a very good question. You've got to analyse your case, really. So you essentially want to make sure you've got witnesses that can cover every aspect of the case. So I'm particularly looking at it from a respondent angle, from a business angle. You need to look at what the claimant's case is and make sure you've got witness evidence to rebut the different elements of their case. So a very basic example would be, let's say you had a very simple unfair dismissal case for misconduct. You'd probably want whoever dealt with the investigation, you'd want whoever dealt with the disciplinary hearing, and you'd probably want whoever dealt with the appeal as well. Now, I appreciate it's not always that straightforward. The key thing is trying to make sure that you don't want to be calling too many, because you will end up elongating the length of the hearing. Equally, if you've got legal representation, you probably end up increasing your costs because it's more witness statements to prepare. But it is a balance, because what you don't want to do is lose your case because you've missed out and unable to answer one part of the claimant's case. And I guess the other thing is that if you're calling too many irrelevant witnesses, your judge may not be very happy with you, and indeed the key points may get lost in the noise as well. But the starting point is to analyse the case from a legal perspective and then work out who you need to respond to it.
Absolutely. Just to give you a breather, Ian, I'll dip in with another quick question so you can pick another one before we have to speak again. There's been a lot of interest in the fact that obviously poor Jasmine was unable to give evidence because she was in Thailand. And Alice, you gave us a very helpful summary of the rules whilst obviously dealing with that issue. But there's been, there's been a lot of question about why that's not okay, when that came in, what do you do if someone lives abroad? If anyone would like to give a summary of that from Devereux, that would be fab.
Sure. Can I just point you in direction of the presidential guidance, which it was handed down in April 2022. It's presidential guidance taking all evidence by video or telephone from persons located abroad. And it followed a decision in another tribunal, the Upper Tribunal of the Immigration Asylum Chamber, in a case called Ababiaka, which is spelled Agbabiaka. And that is the case, the seminal case that changed the rules on giving evidence abroad. And as a consequence of that, you have this presidential guidance and a real change in approach in the tribunal. So it's been taking place for a couple of years. And when it first started, everyone was having to sort of slightly panicky send letters to jurisdiction. But what they've tried to do quite sensibly is approach the different jurisdictions and get a list of countries that you don't have to get individual permission for in relation to each witness that you are having dialing in. So, and there are some quite interesting countries that you can now so unexpectedly have said yes to giving evidence, and some that unexpectedly said no. So for instance, I think Iraq is a country that has said yes. And there are other, countries, I think maybe Germany said no. So anyway, the point is you need to check the list because it's not that obvious. And you need to do that on each occasion. And it matters not whether or not the person is living or just visiting overseas. It applies to anyone who is located abroad when they're giving evidence. Sam, Hitesh, do interrupt and give anything else that you think is needed.
I think from a practical perspective, I had a case back in January where a witness told us during the witness conference a week before the hearing that, oh, I'm going to give my evidence from Thailand. At first we heard of it, and it just meant that she couldn't give evidence. We were never going to get permission within a week, and we had to go back to the drawing board and get someone else to cover the evidence that she was covering. So if anybody is going to likely to give evidence from abroad, or possibly even going to give evidence from abroad, tell your solicitors within good time. That I think is the key there, because last minute surprises, can't do anything about it.
I think it's because I think earlier on you'll be doing case management, and as part of that you take dates to avoid, and as part of the question of dates to avoid as to when you're available and you're not available, part of that question could be, and are you going to be in the country for this entire period of time that you say you are available? So that's a good way to sort of cover off the problem just really early on.
Great. Sam, this is one probably best for you maybe, but the Instagram evidence not being in the bundle, to what extent is it possible to bring in evidence that's been missed out of the bundle and bring it in at the hearing?
I think it depends on the nature of the evidence, but I think in this case I was pushing my luck quite substantially. I think it somewhat depends on how interested the judge is in the evidence as well. If it's somebody's own personal information they will know about and shouldn't have any problems recalling, then you've probably got a little bit of a more leeway than it's something that they've never seen before, they've read before. In which case you're probably going to get told no, if it's not in the bundle, it's not evidence.
You're on mute, Katie.
Trying to blinking that pesky echo. Apologies. So an interesting question that's just popped in, actually, asking obviously about what happens next for Mr. Farmer. Will he be looking at monetary compensation? Will anything of his own behaviours, either whether his grumpy approach, perhaps giving under cross-examination, or the points that he put, have any impact on what he'll be awarded? If anybody would like to answer that.
I'll be making my bias application first, but after that, after that, yeah. So we'd likely end up having a listing for a remedy hearing, and successful on some discrimination points. So we'd be arguing about well, loss of earnings for sure, basic award, compensatory award, which look into loss of earnings point on the financial losses for the discrimination side, interest feelings. Based on the findings, I suspect that might even be pushing for aggravated damages, maybe. So that we'd be probably defending reasonably expensive, I can imagine. Depending on mitigation, I expect we'd be defending a reasonably expensive claim. Yeah.
Sounds good.
Great. I've got sort of another procedural type question. So is it a must that witness statements, investigation notes are signed? What if the risks that they are not? I'm not sure if that's a reference to formal witness statements before the tribunal or ones which form part of a disciplinary process, but don't know. Alice, do you want to have a answer?
Yeah, absolutely. So I'll deal with both. So in relation to the investigation, it is really helpful if you get your witnesses to agree the notes, and you should do so kind of contemporaneously. So you provide the notes to them, get them to agree it, either by way of an email saying yes, they're agreed, or actually signing them, even better, because then you can't have any disputes about what's in the notes if you wish to rely them if it gets to tribunal. So, but also it's a matter of good practice. So that's the investigation stage. With the witness statement stage, they are meant to be signed, but there are many occasions when witness statements are produced, as here, without a signature, and judges are pretty pragmatic about it. They will, if it's actually in person, they might well get the statements signed then and there, or if not, they'll just get the individual just to read out the statement of truth and confirm. And just on that, just a fairly short point, but you'll see that there was a difference in the statement of truth between Nathan Farmer's statement of truth and the other three. The accurate one now is the one on Nathan Farmer's, the longer one. So that's the one that you should be using, which talks about contempt of court. But that just, so correct me if I'm wrong on that, but that's my understanding. That's the one we should all be using. So use the right statement of truth and get it signed and dated, and that's before it goes into a bundle and goes to the judge, preferably. Anyone, please do comment or interrupt if you think you want to add anything.
I think that's the right statement of truth. In tribunals, you probably get away with the wrong statement of truth, but you wouldn't get away with it in the High Court, that's for sure. So better to get it right.
Just make sure if you're turning up to a hearing, have a pen in case you need someone to sign a witness bundle. That's probably the advice I have.
It's a good tip. That's a very good tip. We've had another one asking about, obviously, now today there's a presumption, obviously, that today has been a short form version of what we'd normally see in a tribunal. Certainly for a case like this, it would normally take a couple of days at least. But there was a question about obviously what happens if, say, for example, you've got a 4-day hearing, something along those lines, and you run out of time to either hear all the evidence and or have your closing submissions or judgment or whatever it might be.
Well, things used to go part heard, so tribunals would invariably say, okay, it's a shame we haven't got it done within the day allocation or the time allocation. let's have a look at the diaries and see when we can all get back together. It could be 6 months down the line, could be 3 months down the line, could be 9 months down the line, who knows, depending on the tribunal venue. These days, I'm increasingly finding that tribunal judges are saying, we will not go part heard. You will tailor your cross-examination and the submissions and the evidence to the time we have. Because I think tribunals are under so much pressure that they're just not willing to relist, try and get 3 members of a tribunal back together in 6 months, 9 months, a year down the line and remember where they were at. So I think these days it's becoming less frequent that tribunals are willing to come back at a later point.
How important, Sam, is it then to make sure you get that timetable kind of done at the preliminary stage so you get a good, accurate listing for your case?
Critical.
Yeah,
absolutely critical. And that comes back to the list of issues. You've got to get that list of issues right at the beginning. Until you know what that is, you don't know roughly how long you're going to be. And if you do think you need more time, then write to the tribunal in good time prior to the start of the hearing saying we need an extra day, because it's possible they could add it either end.
Absolutely. And then going back to a point Alice made at the start, which is about lay members, and the question being, what would the lay members' role be if they were there, and also could the two of them overrule the judge?
Shall I pick up on that one? So they are there as equal decision makers with the judge. So the judge generally will be running the case management elements of it and leading on that. But panel members can ask questions of witnesses as well as of counsel during closing submissions. And if they had been there, I would have given them an opportunity to do that. So they are engaging full members of the panel, which does mean that when it comes to decision making, they could, in principle, override the judge. There could be a majority decision of 2 to 1, but it's really, really unusual. I mean, I don't think I've come across in my, I mean, for my cases, I've obviously seen it on occasion with others. Normally there is a unanimous decision, but of course the judge is the legally qualified one, that the two individuals will have more of a, hopefully, a feeling for what happens in industry, and so all of that, when it comes to bear, will hopefully give a good decision. So yes,
it's sometimes the case. I think you'll find you often see is that the quality and the nature of the questions you get from different people on the panel change. So I'll give you a recent example. I had a capability, an ill health capability on fair dismissal recently. I'm getting lots of questions from the tribunal members, one of the panel members, I should say, about, well, why did you not look behind the occupational health reports? Why didn't you contact the orthopedic surgeon, something like that? You know, legally speaking, that's not really what you're expected to do in this case. Also, you're not supposed to be a medical tribunal, and so you can see it. The judge wasn't asking those questions because the judge may be aware of that, whereas the panel member might not, and so you'll see maybe a difference in what's being asked, and sometimes it's due to pick up on that, and then you've got to be alive to that. Well, I need to make a submission really quite directly addressing that, because if the judge doesn't know the answer to this, quite potentially an error of law there. So it does that. Overrule is probably not what's going to happen, but it does. You've got to pay attention to what you can work out, what everyone is thinking on that panel, and then try to tailor whatever you say as a result of that.
Perfect. I think we might have time for just one last question, which I've seen one that's popped in for Sam directly. Someone's just asking, they were saying that you were querying whether the witness had help writing their witness statement, and asking whether or not that's allowed.
Well, it's supposed to be, a witness statement is supposed to be in the witness's own words. And I've had cases before where witnesses have put together witness statements that bear a striking resemblance to another witness's evidence, and it looks like the same person has written it all. And in that sort of circumstance, you can sort of start to crack a witness very early in that, no, this isn't my evidence, no, I don't know anything about that, no, actually that's wrong. And once you've got them on the ropes like that, that is the beginning of the end for that witness. So a witness's evidence should always be their own evidence, always in their own words, and that's why sometimes you can sort of get a whiff that perhaps they haven't drafted it themselves and it's not their own words, and you just explore that and see how far you can get.
Wonderful. Okay. Well, I'm conscious of time. I think we've got about 5 minutes left. So apologies to the questions that we didn't get to answer today, but thank you hugely to those who did. I'm just going to quickly run through a couple of final points. So if you just hang on the line just a few more minutes. Just out of interest for people who may be interested, for those of you who would like an overview of the stages running up to a tribunal hearing, so the bit that comes before what you've seen today, please do head on to the Field Seymour Parks website and have a look at a webinar that was put together by Emma, who you saw earlier, and another one of our colleagues, David Clay. They produced a webinar back in November that was called An Introduction to the Employment Tribunal Process. That may well be of interest to many of you viewing today. Quick reminder while I'm here, please to fill out that feedback form. That would be absolutely wonderful if you could just take a couple of moments. It's going to pop up on your screen when we close in a couple of minutes, but it's also going to be emailed out to all the participants as well. That reminder, you've got that opportunity to win a £50 John Lewis voucher if you complete it within the next 48 hours. So please do so, that'd be great. If you'd like notifications or updates about any of our future events, you can sign up to our newsletters, follow us on LinkedIn, other social media sites, all of those sorts of things, but you can get notifications of those there. We do as a firm run regular webinars, we write articles, provide training sessions, and we even have a quarterly network HR forum for HR professionals that you can come along to. So if you'd like interested in hearing about any of those, please do sign up. Last thing I just need to say is obviously a huge thank you to all of our speakers who've taken part in today. Obviously we've got the FSP team, most of who've gone off camera, but hopefully still in the background somewhere, but who've been very busily preparing and honing their acting skills for today. So thank you to them, and huge thanks of course go to the very much the stars of the show today, Alice, Sam and Hitesh from Devereux Chambers, who without whom today certainly would not have been possible. I have to say it's been an absolute pleasure having you all here and seeing you all in action. It's been a real education and hopefully something that everyone has really enjoyed. Lastly, I'll just finish by saying thank you to all of our attendees. We've been inundated with people signing up, which has been absolutely wonderful. I mean, certainly from a personal perspective, and I'm sure I speak for most of the team, that we've obviously really enjoyed delivering this session today. It's been a lot of fun, but most of all, and most importantly, perhaps, we hope you found it interesting and helpful. If there is anything you haven't had the chance to raise, or anything you want to get in touch with, any help that we can give you going forward, obviously, please do get in touch. We'd love to hear from you, and we really do hope that you'll join us at another event soon. Thank you, everybody.
Thank you, everyone, very much. Bye-bye.
Thank you.